Can you still go forward with your divorce even if your ex refuses to sign the paperwork? My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and designed to inform the public. Please subscribe to our channel. The short answer to your question of whether or not you need your ex to sign stuff for you to get divorced, the answer is no, you don't. I mean, if your ex is smart, he or she will want to sign stuff. You know why? They'll want to weigh in on it. They'll want to read it. They'll want to see what it is. And they may want to say, you know what? I agree to that, but I don't agree to that. So they may want to engage in the process so that they can have it work out for them in a way that's fair as they see it. If they refuse to engage in the process, they are foolish thinking that that refusal is going to stop the process, because it won't. What'll happen is, if they, for example, refuse to sign the papers, they refuse to sign any acknowledgement that they have been served, or they evade service, they hear the process server is coming, to run out the back way. People actually do this. The court will only make you try to serve a person conventionally so many times before it says, all right, you know what? Let's publish. Let's publish it in the legal news. That's how we're going to serve him. We're not going to hand him anything. We're going to publish. And you know what? It's a legal fiction. Why? Because nobody reads the legal news. Lawyers don't read the legal news. So if you think some guy who, let's say, drives a truck for a living is going to be, reading Sports Illustrated and the legal news, that ain't happening, okay? So when he does this, what he ends up doing is shooting himself in the foot, because by not taking the papers and by allowing the alternative means of service, all he's done is say, well, something's going to happen and I'm not going to know what it is, and I guess I'm okay with that. And the court feels, well, I guess he's okay with it because he made us go through this process, had a chance to actually take it and read it and play in our game, decided not to. Now he's going to be stuck with the consequences of that. It could be that they have nothing to talk about, that they have no assets and no children and no liabilities, so it just doesn't matter. That could be. But having run this firm for many years, I will tell you, there's usually something. There's usually something to divide. There's vehicles. There's jewelry. There is personal property. Even if there's nothing to divide because these people are broke. You know what broke people have that a lot of people who are rich don't have? Debts. And you know what? Debts have to be divided too. If in a situation like that, there's a lot of debt and the guy doesn't participate, he or she chooses not to, you know what could happen? They could get stuck with all of the debt. The judgment of divorce could say that, the Visa, MasterCard shall be paid by the one who didn't participate. That's no good. You don't want that. So I would say this. If somebody were to call me up on the phone and say, hey, they're trying to serve me papers, I'm not inclined to take them. Do you think I should? I would say yes, by all means. Take them. Set up an appointment with the process server. Have him give you the papers. It's just as easy to be a nice person as to be a jerk. There's no point in being a jerk. Just take them. Read them. If at that point you decide they're not asking for anything that you care about, then you can have a discussion about whether or not you even want to be part of the process, or do you just want them to default you. On the other hand, you may find, after thinking about it, that, you know what? There are some things that I'd like to weigh in on, and therefore you need to participate in the process. I will give you one cautionary comment. The Michigan court rules, they require of lawyers in drafting pleadings to make a short and plain statement of the facts. The problem with that is that because they only make a short and plain statement of the facts, a lot of times your complaint for divorce will say something like this. Parties were married on such and such date. They have had no children. They may or may not have accumulated personal property. There's been a breakdown of the marriage to the extent that the objects of matrimony have been destroyed. There's no possibility of reconciliation. A defendant wife isn't pregnant or plaintiff wife isn't pregnant. Therefore, we seek an absolute divorce, blah, blah, blah. In other words, it may not talk about your car. It may not say anything about Visa or MasterCard. It may not say there's a lease. We both signed it. She's living. I'm gone. Who's paying that lease? It may not say anything about that. So while we advise that you should always take the papers, or we recommend that you should take the papers, you have to understand one thing. In a lot of times these things are filled out following the strict court rule, which says you don't really say much in them, except that there's been a marriage and a breakdown. So reading them may not really give you a clue as to what the other side wants. On the other hand, at least you can look at it and you can figure it out. Some lawyers are a little bit more loquacious in what they write. They are more inclusive in the things that they put down in the complaint. They tend to talk about debts and liability. Some do and some don't. So our suggestion always is take the papers. If you decide that there's something you're worried about, get a lawyer and you'll defend your case. If you're not worried about that and you don't care, well, that's a decision that you have to make. Now, if you have any questions about this, reach out and we'll be glad to help you out.